Welcome to one in a series of webinars by California Indian Legal Services on the Indian Child Welfare Act as it applies to California children. My name is Mark Radoff. I'm a senior attorney with California Indian Legal Services, and today's topic will be about ICWA and the delinquency system. California has two separate tracks for minors. One is dependency, one is delinquency. They're both found in the Welfare and Institutions Code in separate sections. One is in section 600, one is in section 300. Did not apply to delinquent minors. That is from the federal law and from subsequent case law. However, there was a point in time back in 2012 and before when California probation departments and social services were using 4E money, and it triggered the application, at least for a short period of time, of the ICWA to delinquent minors. The INRI WB case was the only case in California to address the issue, the only Supreme Court case, and that was decided almost 4 years ago now, in 2012. This is the case citation for WB. The opinion was to decide whether or not the ICWA, which typically is triggered by removal of children from their families, also applied to children when they are removed for delinquent activity. Delinquency is essentially criminal conduct by minors that occurs, that would be a crime if it was committed by an adult. And the federal law, as I said before, excludes the application of the ICWA in those scenarios. But because of the 4E funding situation, that triggered an overlap, and that was what caused the Supreme Court to take the case. The population of minors who are delinquents or dependents is not necessarily a bright line. Sometimes it is blurred because the conduct of kids who get in trouble is theirs, but the conduct of the family or parents that causes them to be within the system, to be supervised by social services, is a different source. It's the same kids, and sometimes it's the same exact plan for reunification, same exact supervision, but the systems are different and the penalties are different, which is the main distinction. SB 678 was California's version of the Indian Child Welfare Act. Although the act was originally passed on the federal level in 1978 and states followed it to varying degrees through cases and rules of court, California did not enact its own version until, I believe it was 2006, and the Senate Bill 678 was the name of the bill at that time that applied the ICWA to California. It's now commonly called Cal-ICWA or California ICWA, and the sub-issue that triggered the question of whether or not the ICWA applied to delinquent minors was whether they were at risk of entering foster care. That was true even if parental rights were not being terminated. The lower court in that case, the WB case, took issue with whether or not the minimum standards for delinquent minors applied. So what does at risk mean? At risk is a moving target. It's essentially whether or not there is a possibility, a chance that the children might be removed from the home. If a report recommends removal, then they are at risk. And so when a child is detained in a dependency case, they are at risk of foster care. If a child is removed from their parents' custody in a delinquency case, put in juvenile hall, they are at risk. But juvenile hall is not considered foster care, so there's some fine distinctions, at least at that time, that had to be addressed. It's a little bit more clear cut because by way of spoiler alert, the WB case contracted the application of the ICWA, so it's a fairly narrow set of circumstances where it might apply today. These are some of the statistical background, the statistical numbers. There were 63,000 children estimated to be in foster care in July of 2009. Another 5,000 were being supervised by the probation department. Although the probation foster care placements were a subset of regular placements, they still triggered or could trigger the higher requirements of the Indian Child Welfare Act. And according to the study, the Danielson and Lee study, 96% of probation supervised minors were first removed from parental custody and then placed in a group home. Group homes can be considered foster care under the definition of the Indian Child Welfare Act. So the question, the basic question is whether or not a tribe needs to be notified, child's tribe. The RR case, the citation is on the slide, held that the notice requirements apply to a delinquency proceeding where, again, the minor is at risk of entering foster care. So that's, even though that's somewhat of a vague standard, at risk, there's moments in time where it can be determined more definitively when a child is at risk of entering foster care. For example, when they've been put in foster care. The notice is really what is the main way that a tribe could know or participate in a case. If they don't have notice, as obvious as it sounds, they can't participate. And if they find out too late, then their remedies or the role that the tribe might play is diminished. Riverside County took the opposite view in WB and held that the legislature could not expand the ICWA protections beyond the federal standard because of preemption. So in their view at that time, preemption meant that there was a ceiling on what the state could do, even though the act is framed in the phraseology of minimum standards. Prior to 2006, California applied the Indian Child Welfare Act through rules of court, which are rules adopted by the Judicial Council and interpret the gray areas, the parts of the law that are not specified in either a statute or an initiative. The federal law, which is found at 25 U.S.C. in the 1900s, has allowed, and in section 1911C, allowed Indian children's tribes to intervene in a proceeding for foster care placement at any stage of the case. So intervene means to come in as if one were a party. But the tribe's right to intervene, of course, as I mentioned, is meaningless if they don't know about it. There's an old case, now old, from 1983 in Re Junius M. The citation is there, which speaks to that issue. Federal law, Section 1903, defines child custody proceedings to include foster care placement. Child custody proceedings, that is the definition that will open the application or trigger the application of the Indian Child Welfare Act. It is defined as any action to remove an Indian child from their parent in a temporary placement where basically the parent cannot have the child returned upon demand. And this is where, in the scenario where the parental rights have not been terminated. The inquiry and notice, which are two separate things, inquiring if a child has Native American ancestry and then giving notice, those two separate requirements are found in California Welfare and Institutions Code section 224.2 and 224.3. I would, as a side point, Welfare and Institutions Code also includes other laws, but the main areas that we're concerned about for children are the section 600 and section 300, though as you can see, there's a 200 section, which is a general part of the law, and so the gist of it is, to know which law applies, you'd have to be looking in somewhere in the W&I code or in the rules of court, which have now segregated the Indian Child Welfare Act and the dependency rules and the delinquency rules in their own sections, though there are specific rules where they are of general application. California now exceeds the federal ICWA by imposing a duty of inquiry where a child is at risk of entering foster care. That's the RR holding, and that is where there is a chance that a minor might be put in foster care. Under 224D, where the state or federal law imposes a higher standard, as in California, the court is required under the law to apply the higher of the two standards. I mentioned this a moment ago. Is inquiry the same as giving notice? Not really. Inquiring is asking. Giving notice is what you do once you determine that a child is a either a member or eligible for membership or has the possibility that they could become a member. And the inquiry forms have a daunting amount of information that is designed to go at the issue from various points of origin, whether they're getting any benefits, whether the family has been going to IHS, their family tree, it goes on and on. But the inquiry is supposed to produce a set of information that would give the agency, and I'm speaking of both social services and the probation department, the tools to determine who the potential tribes are, the putative tribes are, and then they would give notice. But the WB court, which was the Supreme Court case in California, held no. They made a distinction, that same distinction, that notice and inquiry are not required, only inquiry. So Section 224.3 creates that obligation for the Welfare Department and probation to ask and to inquire about an Indian status in all dependency cases and in delinquency cases where the child is already in foster care or at risk. Again, at risk, this keeps coming up, is the term that means conditions in the minor's family may necessitate his or her entry into foster care. The section 727.4 is not a 300, it's not a 600, but it's a section that probably still applies to both, but is traditionally been used for delinquent minors and is it's where the probation violations, the probation sections are. Now, the key point, or a key point, is California has a process for dual supervision of children who fall in both types of cases, delinquency and dependency cases. The traditional system was that you couldn't be one or the other. You had to either be delinquent or you had to be dependent. California would require the probation department and social services to get together and make a recommendation, a decision, through what's called a protocol, and pick which system. They are treating minors differently. So the delinquency is as I said, a punitive system. It can lock up the minor, take away aspects of their liberty, driver's license, they restrict where they go to school, restrict a variety of things that can be enforced by the courts as if it were criminal. Whereas the dependency case, the doomsday remedy is to separate the family and to find a new home for the minors. But some children fell within both systems, and that was where the protocol came into play. The protocol is under Section 241.1 of the Welfare Institutions Code, which required counties to make an election to choose dependent or delinquent. And at that time, not now, but at that time, there was no provision to have dual supervision. So you basically got one or the other. The the first come first serve what I mean by that is that it typically would be the case that whichever system first took jurisdiction was the one that would keep jurisdiction of a minor. And so for example, if a delinquent minor was on probation and then later the family came under the notice of the social services, there would still be a weighting or a likelihood that the delinquency system would keep jurisdiction over the minor, even if there were other kids in the family. There's an argument to be made that they should all move over to the dependency system, but that's what the protocol was designed to do, to look at it on a kid-by-kid basis and make that determination and then make a recommendation to court. The protocol cases were sometimes called 450 cases, or I would call them 900 cases. 450 because they were in between 300 and 600. 900 if you if you add them together, you get 900. It was, in a sense, like crossing laser beams. You really were not supposed to mix those two populations of children, but that happened with some frequency, and so the court had to, state had to figure out what to do with these minors. The rule of court 5.481b2 is the one that requires a probation officer to send notice to the parent or the tribe in 601 and 602 cases. And if you opened up the rules of court to that section, and I'll make a side comment on rules of court, they're not numbered intuitively, and they change from time to time, so they're generally grouped together, but these are the rules that the Judicial Council and the courts have relied on to address the specifics, the meat of issues that may be slightly unclear or in any way ambiguous in the statute, which is what has been passed by the legislature. The Rule of Court 5.481 has two parts. A is inquiry and B is notice. So the notice section includes everyone who has to give notice after inquiry, and that rule of court does apply to 601 and 602 cases, although with the ruling in WB, it's more likely that it's going to be only 601 and then a narrower subset of 602 cases. And I'll just identify what they are. 601 are status offenses. 602 are the crimes that kids commit that, if committed by an adult, would be a criminal act. Historically, delinquency cases were exempt, or at least believed to be totally exempt from the Indian Child Welfare Act. That has been passed down, but for some of the crossover issues, the dual jurisdiction and also the 4E money, that might have remained the same. It's not, though. There's a sliver of the population that where it does apply. This is going backwards a little bit on the process. This slide is about review and how a state, the California Supreme Court, takes the cases that it considers. The review is discretionary, so the Supreme Court does not take every single case that comes before it. Many cases are petitioned for review. Not all. In fact, very few are accepted, though most, if not all, cases can be appealed through the Court of Appeals. They're not automatically reported, they're not automatically citable, but there's a huge number more, a vast number more of appellate cases than there are Supreme Court cases. So when a Supreme Court takes a case in California or any other state, it's a big deal, and it means that this is going to be a definitive ruling, at least on the particular issue that they've taken. So that's what this slide says. It is the final word. on this particular issue in WB, the court did not categorically exclude the Indian Child Welfare Act to minors who commit adult crime acts, but it was almost that way. So if you look at the facts, it it narrowed the application to just very, very particular circumstances. In the case itself, WB was a minor who had a number of 602 petitions, delinquency petitions. By overlapping, I mean that he had not they hadn't finished adjudicating a case before he had a new violation. So he was out. They were in the process of litigating or adjudicating the case, and then another violation happened. Normally, the sequence would be there's a violation, there's probation, and then if a new case happens or a new crime happens, then the court or district attorney has to decide whether or not to charge a new crime, or charge it as a violation of probation. When they are tiered, that just complicates matters a little bit. Somewhere in that process, WB was identified as an Indian child, and I believe they treated WB as an Indian child for all but one disposition. Disposition, substitute the word sentencing. It's the process for the court to, after an adjudication, for the court to decide what to do with a minor, what the terms and conditions of probation are. In a dependency case, it's the reunification plan. But no notice in this case was given to the tribe, so there was a factual question whether he was eligible, but there was no notice given, so that ultimately could not be decided. Though it was foreseeable that WB was at risk to enter foster care, and his recidivism, which is repeat offending, suggested that he was in need of a more serious type of placement, which means probably secure confinement. But he was returned home, so the lingering issue was whether or not he was at risk to enter foster care, even though the habitual violations suggested he might over that and go into some kind of a secure facility. The Attorney General's view on this case was that the expanded notice requirements to the tribe in these cases conflicted with federal law, with Section 1903, and federal law contained a carve-out, an exemption for delinquency cases. The court, according to the Attorney General, should have considered the statutory scheme as a whole, and it did not confer new rights on tribes in Section 600 cases. So the AG's view was that notice, just to give notice if they can't participate, was meaningless. The WB ruling took issue with the RR finding. The RR was the citation earlier because it did not do what the AG suggested, which is look at the statutory scheme as a whole. There was also a sub-issue of preemption, which comes up every single time that California can't do anything different, can't vary at any juncture or in any way from federal law, which is hard to reconcile with the idea of minimum standards. But preemption was not really decided by this case. It was they took their foot off the gas on that issue from the AG side, and they did adopt the federal definitions in 224.1, and those were incorporating the federal law, which is where you get the exclusion of delinquent minors. Basically, California plugged in federal law into its definitions, and the point being that the plugging in then means that we don't vary, at least as far as the definitions go. The court's interpretation of the Indian Child Welfare Act looked at whether or not the removal was motivated solely by concerns of parental abuse or neglect, and stopped right there because that's almost impossible to determine. It's possible if a court makes a finding that says that, but in a normal circumstance, the stew of events that leads to a minor getting arrested and incarcerated is from multiple sources, and so to know that it's motivated solely by concerns about that would be a difficult thing to identify. Without some kind of help from the court or some kind of written finding, that's probably not going to happen. But that's the scenario. That's the way that it would apply. So it has to be solely by the parental abuse or neglect that caused the minor to do something delinquent. So maybe there's a case where a parent enlists a child in some kind of trafficking or other activity that's neglectful, and it's not the minor is a passive participant or something. I don't know. I can't think of a scenario where it might apply, but it's possible, and so the door is not shut. In all other cases, though, the 602 cases, it will be presumed that it's based on the minor's conduct alone, and the ICWA does not apply. 602 and 601 are neighbors in the code, and they are two different types of uh, wardships. One is the 602 cases is the main one that you'd see. It's prosecution for minors who commit criminal acts, and if they were an adult, it would be a crime, or for certain allegations, for certain charges, if they're 14 years or older. So there's more serious charges, murder or rape, that are committed by the 14 to 18-year-old child would also be 602, and there's a procedure for that, a fitness process where the court and the district attorney have to show that the minor falls within the higher category. 601 cases are basically truancy. They're status offenses: truancy, school attendance, runaway, curfew, alcohol possession, acts that are committed because that are chargeable because they have the minor's status. So if they weren't under 18, they wouldn't be culpable. The scenarios where placements are not based on a criminal act, in other words, where the ICWA does apply, are status offenses, the 601s on the preceding slide, the truancy, alcohol possession, graffiti. Probation violations are something separate. That's a promise to the court for leniency or for a lesser sentence or for informal probation but this would typically come up with formal probation, and it's broken. One of the first conditions of probation is usually obey all laws, and so if a minor doesn't obey a law, or something else, it could be skipping school, it could be anything that's in the conditions, that's a violation of probation, and there is a separate procedure for probation violations. It's easier to prove, and there's due process requirements, so you have to have a hearing, and the same attorney who would be appointed for a minor in a 602 would probably be appointed in a probation violation. But the court made that distinction that a petition that could be based on something that's not a criminal act, and that therefore the placement is not based on the criminal act. So put another way, if a minor's placement were changed because of a PVC, probation violation complaint, that's not technically criminal, and so therefore the placement is not based on a criminal act. Therefore, the argument would be the ICWA does apply. That doesn't help if there's a new charge and there's a new allegation of criminal activity. Then you get into the nightmare of trying to untangle whether or not it is the new crime or the old probation violation that caused the placement. That's for trial counsel to argue, but that's a scenario where the act could apply, does apply, and just underscoring the same point on 601 cases. 601 cases do fall categorically under the ICWA because they are not criminal. So 601s are not criminal. The status offenses, uh, they may seem like ticky-tacky minor things. They are less serious than 602s, and they are defined as acts that would trigger the application of the the Indian Child Welfare Act. So 601s, yes. 602s, most of the time, no. WB, getting back to the ruling, held that the rule of court was overbroad because it did not account for the limited applicability of ICWA in delinquency cases, and that same rule 5.480 was at that time requiring all notice and inquiry in all 601 and 602 cases. The rules of the Judicial Council are valid or authoritative only to the extent they are not inconsistent with the law, legislative enactments, or the Constitution, and the Supreme Court took issue with the breadth of the rule of court. Dual status. So this is the case I spoke about earlier about the hybrid situation where a minor can be both or potentially both dependent or delinquent. And the protocols are written protocols. Every county is supposed to have one. I don't know if they all do. I think the distinction now is there may be some counties that have a protocol on dual supervision, but not they have dual supervision protocols, but that's not the same as a protocol with respect to choosing which system that a minor needs to fall under. In the cases where the Indian Child Welfare Act applies to 600 cases, some of the ICWA requirements conflict with a minor's rights. So a minor has a right to a speedy trial by the Constitution. Waiting to give notice to a tribe, especially if the tribe is not known or a tribe is not communicated with the court, means that a minor might remain in juvenile hall longer than they need to. The same thing with a transfer to tribal court. There could be pushback from the prosecution, from the district attorney, because in a dependency case, a case can be transferred at the earliest possible time to the tribal court. A transfer in a 600 case could compromise the prosecution if witnesses can't get there, victims. If the prosecution feels that court might not vigorously prosecute, that's not to say it can't happen, but it is an issue that has been raised by the district attorneys and probation. Also, the requirement of a qualified expert witness to determine if it would be detrimental to leave a minor in their parents' home is not really an issue in delinquency cases, but that's required under the Indian Child Welfare Act. So applying the ICWA to delinquency cases is not an automatic fit on every aspect. Still, the Indian Child Welfare Act does apply in some 600 cases. And this is essentially a repeat of some of the earlier information, but assuming that the minor is an Indian child and the probation made inquiry and determined, this court found, the WB court, that it was not error, it was not erroneous to fail to give notice in the WB case. And that was really what the whole issue was, whether or not the conviction should be upended, it should be reversed because the minor's tribe did not get notice. The 4E money that I mentioned earlier was, it may still be an issue, I don't know, but 4E money was being used for foster care placement for delinquent minors. 4E has its own requirements, and they require a case plan and certain findings that have to be made, and that was how it backdoored the requirements, or potentially backdoored the requirements of the Indian Child Welfare Act. The 727 is the section in the Welfare and Institution Code that carves out the possible placements for a probation officer to recommend: one, a relative or extended family member; two, a suitable care facility; or three, a licensed foster home. And some of these banners there, I think there were some pictures here that aren't there, so this is a heading that basically reiterates what was just discussed a moment ago. The 4E issue, 4E funding issue, was really what started this, and to the extent that there may still be 4E funds being used, then maybe it's still an issue. I don't know at this point. But 4E funds do not allow cannot be used to punish a minor. So if the placement is a punitive one, then you'd have to find, it probably would go facility by facility, but the point is that there are limitations on when 4E money can be used, and it's probably a composite of funding that's used by the county, so it may not even be totally clear what percentage of funding is being used. I don't know. I think that would probably be on a more of a case-by-case basis, but the detention facilities or camps or things like that which are primarily used for delinquent minors can't be funded by the 4E money. Same point, incarceration, can't use them to lock up the minors. The BI regulations were released this month on June 14th, and the regulations are stronger than in their current form than the 2015 revised guidelines. The guidelines were a redo of the 1979 guidelines that came out after the 1978 Act. Guidelines are persuasive and, at least in California, have been incorporated into case law on an issue-by-issue basis. Based on that, though, the Bureau went and upgraded the guidelines and released them last year, and now upgraded them even further to the point that they're a federal agency regulation. They do not take effect until December, however, and it may be that there are additional guidelines or guidance that's issued based on the present version of the regulations. However, the regulations affirm that a placement, including juvenile detention, resulting from a status offense, meets the definition of foster care placement. So, in other words, 601s still are under the ICWA, but the regulation more or less adopted by comment, the WB holding, that placements for delinquency are presumptively exempt from the Indian Child Welfare Act. Presumptively meaning in most circumstances. There's that slide about whether the primary reason or the sole reason was because of parental abuse or parental failure to supervise, or however that can be peeled off. It's most likely going to be the case that delinquency proceedings are not subject to the Indian Child Welfare Act procedural requirements. So what would the takeaway be? The takeaway would be that for cases with multiple causes, make a record. If there's any question that there may be a composite of causes, make the record. That's probably the only way to identify whether or not notice or substantive application of the Act should apply. For dual jurisdiction cases, the 241.1 protocol, where a county can supervise under both, so you got a 300 and a 600 agency supervising, that is going to apply, and a probation violation, I talked a little bit about that, will apply the Indian Child Welfare Act, not if there's a new crime, but if it's just a probation violation, yes. and then and in those cases, the lawyer or the advocate should identify the child's tribe, request to give notice, and request application of the substantive aspects of the Indian Child Welfare Act, because notice is just the beginning, and that's tended to overweight the process. We've given notice, but then we don't always get to the substantive application. So bottom line, the WB case narrowed the application, but it still can apply. The Indian Child Welfare Act is not automatically, though, going to be part of the delinquency system. So uh, read the WB case. That would be my final point. Read that in conjunction with the current BI regulations. It's easy to search in the BI regulations. You can search by topic or words, and the WB case is the final word in California on application of delinquency and ICWA. So thank you.